Good evening, everybody. In just a few minutes. Well, as you know, the sponsor tonight is citizensjournal.us, Ventura County's newest newspaper, which I'm the publisher of, and I see quite a few subscribers. Some of you are subscribers, by the way, voluntary or otherwise. Right. Well, about 2 years ago, some people got together, and we were complaining about the media. Don't you always complain about the media? So we decided to actually do something about it. And we decided, crazy I know, to start our own newspaper. So that, on December 6th, this is our youngest columnist, Tyler, raise your hand. We actually have a 10-year-old columnist who makes a lot more sense than the editors of the Star, by the way. So anyhow, back on December 6th, we decided to go ahead with this project, and we started publishing on June 21st. Primarily online. We've actually done one print edition, but we can't afford to do more right now. Well, currently we have a little under 3,000 subscribers, and our goal is to reach 30,000 subscribers by November of next year. Any idea why November? Election, right. We feel that we could influence the outcome of elections, not by propaganda, but by just telling the truth. Those of you who read our newspaper have noticed that some of the content looks like news articles, very objective. They're in the news section. Then we have another section called news, editorials, and they're all entitled Viewpoint. And our goal is to make the articles as objective as possible. The editorials are something else, as you might have noticed by right now. We encourage anybody who wants to write and submit those things to our editor. That's why we call it Citizens Journal. It literally is written by citizens. None of us are paid. We're all volunteers. All of our equipment was donated. The only money that we have is what we raise through advertising and the few people that elected to give us paid subscriptions. And we had to decide, do we want money or do we want subscribers? We decided we want subscribers first. However, we will be providing premium services in addition to people who would like to subscribe and pay, which you can do by going on and taking a premium subscription, which would help support this newspaper, which we greatly appreciate. Tonight, if you're thinking about spending money, though, we'd like you to spend it on Paul Beard. There's a reason that we invited Paul tonight. He embodies everything that we're trying to do, namely taking civic action to improve our country. Paul is here to talk about two extremely important cases which he's in charge of. One is probably the biggest landmark property rights case in many years, which he'll tell you about, which greatly expands the right of property owners and protects them against having unreasonable extortionate fees placed on them in return for building permits. The other one is probably even nearer and dearer to your heart, and he was only going to mention it, but we persuaded him to spend more time on it, is that he's also the lead attorney for a major challenge to the Obamacare, quote, law. And this particular challenge had nothing to do with taxes or fees. It's based on the fact that it was illegally passed. And he has a very strong case. I just hope that we have an objective judge. So are you all set up? Okay. Well, Paul heads up the property rights group of his organization, which is called the Pacific Legal Foundation. And he'll be here to talk about those two cases tonight. I'm not going to take a lot of time. I'd rather have him spend the time. So without any further ado, Mr. Paul Beard.
Thank you, George. Can everyone hear me back there? I want to thank George for setting this up for us. This is two subjects that are very near and dear to my heart, obviously property rights, but particularly today, Obamacare with everything that's happening. And the purpose of the talk is twofold. Number one, with respect to the property rights issues I'm going to discuss today, the purpose is number one to get new clients, because we're always interested in representing property owners who are facing government extortion or government abuse, particularly in the permitting process. And number two, it's to spread the word about your rights, because a lot of permit applicants in particular, but property owners in general, they don't know what their rights are. And so the point of this talk, and the point of our going up and down the state to discuss these issues is really to inform people about their rights. And I hope all of you can take something away from this talk tonight about, if you're in the permitting process in particular, what your rights are and what you can do to protect them. With respect to Obamacare, my purpose is simply to give everyone a little bit of hope that there still is a chance that Obamacare could come to an end. Even though it's already starting to be implemented, as we know this past week, there's still a chance that the courts could strike it down, and I'll share with you some of the ideas why we think that's still the case, and we're not being too optimistic. So to start with, I want to discuss a little bit about what we are, who we are. For those of you who may not know, we were founded back in 1973 by a cadre of then Governor Reagan's administration. And it was a response initially to all of the environmental and anti-development groups that existed in the late 60s, early 70s. These were nonprofit legal foundations that were suing property owners, that were suing developers over environmental issues, and they were suing businesses and the right of people to their businesses to be able to make a profit, to sell their products. And so a group of then Governor Reagan's administration decided to found this organization, Pacific Legal Foundation. Its purpose was to represent people for free. And we take those cases only that we think will establish important, either statewide or nationwide precedents. So obviously we can't take every case. We can only take those cases that present really crisp and clean legal issues, mostly constitutional issues, that will then serve to protect all of us, not just the parties to the case. So you may be wondering, how is it that we can represent people for free? Well, there's 20 or 30 attorneys at the foundation, as I said, that take up these very unique cases. And we do so based on the donations of individuals like you and others who really believe in property rights, individual freedom, and our founding principles. That really, we don't take any government money, obviously. And so we're a donor-based foundation, and we've been around, as I said, now for over 30 years, for 40 years. The various practice areas, people often ask, well, what areas of practice in particular do you perform? We have three major areas: property rights, which is what I'm going to talk about today, and that's my specialty. Then there's an environmental practice group, which is sort of like property rights, but really it deals with federal agencies, state agencies that regulate property owners, mostly out of business or out of their homes or out of their lands. We're talking about the EPA, the Environmental Protection Agency, and other agencies who very aggressively enforce their laws against the rights of property owners. And then there's a third area, individual rights, what we call individual rights. It's sort of the potpourri. We do free speech, mostly for businesses, because we do believe that even businesses, not just individuals, have the right to speech. And we do a lot of campaign finance reform. We're not in favor of the campaign finance reform laws that have recently been passed. We think that every individual and every business should have a right to spend their money on candidates and groups and issues. And of course, this area, the individual rights area, includes the Obamacare litigation, which we think is fundamentally a question about individual freedom. So I thought I'd save sort of more passionate issue for the second part of the presentation. That's the Obamacare part of it. And instead start with property rights, and in particular, a recent case that we won at the United States Supreme Court that will affect all of us. And again, I'm hoping that not only will I be able to share with you the kinds of cases that we take on, but also to inform you what your rights are as a permit applicant, as a property owner in general. So this is, are there a lot of constitutional enthusiasts out here who sort of read the Constitution, know what it says? Okay, there's about half of you or so. So a lot of this may be repetitive, but for those of you who aren't aware, here you go, someone has their handy Constitution there. So for those of you who may not be aware, there is a concept, a very important, probably one of the most important constitutional protections that we have in the Bill of Rights, the Fifth Amendment, that says private property can only be taken for public use. We all know that. And also, if it's taken for a public use, just compensation has to be paid. And it's this latter provision that really we have so much trouble over, because over the last 50, 60 years, in particular with respect to land use regulation, we have seen more and more federal, state, and local agencies trying to evade that requirement, trying to take private property through their regulations or through their ordinances without paying just compensation. How do they do it? Through the permitting process. That's the number one way in which they do it. So this is the constitutional provision that really is the basis of our property rights practice. And as I said, most of our practice has to do with property rights in general, but more specifically with regulations. So we do some eminent domain. Everyone knows what eminent domain is, obviously, right? Where the government comes in, condemns your property, takes you to court, condemns your property for public use, and pays you compensation. As I said, governments no longer have money these days. So what do? Instead is use ordinances and statutes and rules and regulations and mandates to basically take property without having to pay for it. And so regulatory takings is really our area of practice. That's where the government gives us most of our business. And in particular, in the permitting context. Most of you here own a home, right? Okay. And so as homeowners, you may want to do something with your property, add a room, add a garage, maybe expand your home, maybe replace it with another structure. All of you will have to face this issue. And it all begins really, the constitutional law on permit takings starts with this case, Nolan versus California Coastal Commission. And this case was litigated back in 1987, but it's probably one of the most important property rights cases ever of all time. Just because it really does affect us every day. We get calls every day about this issue, and so it's important to know about this case and what it stands for. So here's the Nolan family now with their remodeled home back in the late 80s. The Nolan family wanted to replace a small bungalow with a single-family home along the beachfront area of Ventura County. And they were allowed to do so under applicable zoning laws and regulations. There was nothing illegal about it. In fact, all their neighbors had a single-family home just like they wanted. And so they applied to the California Coastal Commission. And if anyone knows the Coastal Commission, they're probably the most anti-property rights agency in the entire country. I mean, they're run by communists, basically. And anyone who lives or owns property in the coastal zone knows this. And so they had this policy in place in the early 80s of basically trying to socialize the entire coast. What does that mean? Well, here is a picture of the Nolan's beachfront property. It's, I believe, I think it's the second property that you see there from the left. Many of you may or may not know, but in most of California at least, private beachfront owners own everything up to the mean high tide line. Everything beyond that is state land. So the Nolans had their bungalow with their, what I'll call their private backyard. Why is this important? If you walked along their private backyard, you could actually peer inside of their living room. So it was very close, and it was a sort of a privacy issue for them to make sure that remained private. So when they went to the Coastal Commission and asked for this permit to simply do what the zoning regs allowed them to do, the Coastal Commission thought to themselves, well, boy, this is a perfect opportunity for us to take something without having to pay for it. And that's exactly what they did. They demanded that he give up, that he dedicate to the state his private backyard and make it public, so that the public could recreate on that area, they could pass back and forth, they could lay out on the beach, and they could basically invade his privacy. And he had kids, and so he had that concern as well. And he said, absolutely not. I'm not going to give you a beachfront access to the public, which is a valuable part of your real estate to begin with, let alone the privacy issues. And so he sued the California Coastal Commission. Now this is where it gets interesting. Why did the Coastal Commission say it wanted this private backyard for the public? The Nolans argued, well, what's the connection here? I'm just trying to build a home, and I'm allowed to do that under the zoning regs, so why are you forcing me to give up my land in exchange for that, for what I'm entitled to? And the commission said, well, this is the problem. And I think they made this up as they went along in the litigation, because they had to come up with some justification. They said, because you're replacing your bungalow, which was a one-story structure, tiny structure, with a two-story single-family home, you're contributing to the impact on visual access from Highway 1. More specifically, and I have a picture there of his neighborhood with Highway 1 way, way, way back there. And they said, you're contributing to a quote-unquote psychological barrier in the minds of Highway 1 motorists, leading them to think that there may not be an ocean on the other side of these homes. And that's in the court opinion. This is precisely the reason they gave. That he was contributing to this negative visual access. And so they figured, well, we can remedy this if you give us your backyard. Now you simply wonder, like, what's the connection? How is giving people public access to walk back and forth along their backyard going to remediate a visual access problem from the highway? There's no connection there, right? And that's precisely what the Nolan family argued. They went up to the California courts, and then actually the Pacific Legal Foundation took over this case at the United States Supreme Court level. And the Supreme Court ruled in our favor and said, in a 5-4 decision, that this was quote-unquote an out-and-out plan of extortion on the part of the California Coastal Commission. That agencies must now demonstrate, they have the burden of demonstrating a connection, an essential nexus between the impact of a project, in this case building a new home, and the need for public access. Absent that connection, it's just extortion. So for example, what does that mean? If the Nolan's new home had destroyed existing public access somehow, maybe the expansion tread upon existing public access alongside the home, the Coastal Commission might have been justified in saying, well, you've got to provide us access elsewhere. But in this case, their new home affected no existing public access, zero impact, and therefore there was no connection. And it was just an extortionate ploy on the part of the Commission to, as I said, socialize the entire coast. So this is a case, obviously, that had a lot of precedential value over the next 30 years or so. We've used it on a weekly basis with property owners. It's become a very important precedent for all of us. And a subsequent case that I won't get into very much has to do, well, how close of a connection does there have to be? In this case, the Supreme Court said there has to be rough proportionality. So not only do you have to make sure that you're justified in exacting this property interest from the landowner, you got to make sure that he's actually bearing only that impact that he's causing. You can't make him, for example, bear the entire impact of an entire community just because you happen to have him in the permitting process. So this just basically defined how close of a connection there must be. Now here's the problem. Government agencies, as many of you know, are very creative. And so what did they do over the following 30 years? They tried to limit the scope of these two cases. They argued to the courts across the country, not just in California. They tried to tell the courts, well, look, those cases, they just involve takings of an easement or takings of land. But when you're talking about money, say an in lieu fee or a monetary exaction of some kind, you shouldn't require us to make that showing because money is different. Money is not really property under the Constitution. Land is property, but money, it's not property under the takings clause. And so therefore, don't apply these two cases which require us to make a very difficult showing. Don't apply these two cases when we demand money from a permit applicant, when we impose a financial obligation for him to pay for some public project. So that was one way they were trying to skirt these Nolan and Dolan cases, obviously to the detriment of all of us. Another way they tried, and this is even a bit more scandalous, the way they tried to limit these two cases. They said, well, those two cases involve a situation where the government approved a permit application and simply attached a bunch of conditions. And it makes sense that you can challenge those conditions if you don't like them, even under Nolan and Dolan. But what happens if instead the government doesn't approve your permit with conditions, but instead pulls you to the side before your hearing on your permit and says, will you first agree to these conditions? If you don't agree, we're just going to deny you outright the permit. And now you don't have a permit in hand. And without a permit, you don't have any conditions. And without any conditions inside of the permit, what are you going to challenge? Nothing has been taken, nothing's been imposed on you. You just have a permit denied. And on this basis, also, they try to distinguish these two very important precedents. So PLF was fighting for years to get a case before the United States Supreme Court to resolve this conflict that started to spring up across the country about this. Texas and a couple of other states saw it our way, maybe predictably. But other jurisdictions, the more liberal jurisdictions, said no, Nolan and Dolan have to be very narrowly applied. The government can do anything it wants, in particular with respect to money exactions. And this was a problem. Why? Because now we began to see permitting agencies demanding all sorts of monetary exactions from property owners. Pay us $10,000 to build a new school. Pay us $100,000. They would tell the developer, hey, give us $100,000 to build a new football stadium down the street. And so they were asking all of these sorts of conditions on property owners and escaping any kind of review by the courts. They didn't have to show any kind of connection. So this was obviously very worrisome for us. We tried to get a case before the Supreme Court. We finally did last year. This is the case called Kuntz versus, it's a very long name, St. John's River Water Management District. We'll just refer to them as a district. And this was the case that actually resolved this question: how far does Nolan and Dolan go? How far do these protections go? Very briefly, this is a case out of Florida. This gentleman, Coy Kuntz Sr., who has since died, he started this case in 1994 and it's still ongoing 21 years later, or 19 years later. He owned 15 acres of land in Orange County, Florida, outside of Orlando, at the intersection of two major highways where everything had been developed except for his vacant land. He wanted to develop just 3.7 acres. Goes to the district because he happened, unfortunately, to lay his land lie within a wetland zone. What does that mean? Not that his land had wetlands, but that he and his neighbors, if they wanted a permit, they had to make the showing that there weren't any wetlands. And they had to apply, even though there weren't any wetlands on the property, they had to go through the motions. So he did that. And he went and applied for a permit to the district, and the district said, we understand that the 3.7 acres that you want to develop have zero wetlands on it. Nevertheless, the remaining portion of your property does have some wetlands, and we want you to dedicate that to the public. We want you to put that into a conservation easement that you can never, ever develop. He reluctantly said yes. The day before the hearing, the district calls him up and says, not only do we want an easement, we want you also to finance public improvements to our state-owned land located miles and miles away. We want you to fill ditches, we want you to replace culverts, we want you to build a new road, all to the tune of $150,000. When at the hearing he refused, the district denied him his permits outright. Cleverly, right? Because without a permit, all he had was a permit denial, no conditions, just a permit denial, so what could he challenge? Nevertheless, he brought the issue to the Florida courts. There's his son, Coy, and as you can see, the property is mostly, it's entirely dry, and to this day, it has not been developed, thanks to the government. Went to the Florida courts, the Florida trial court saw it his way, ruled in his favor, said this is a Nolan-Dolan violation. There's absolutely no connection here between his 3.7 acre development and the need for him to perform off-site improvements on government-owned land. Zero connection. Florida Court of Appeal agreed, but the Florida Supreme Court reversed on these two issues. Number one, it said, well, that heightened scrutiny standard doesn't apply to money, because money is not property, remember, under the takings clause. And number two, they denied him his permit. So what are you challenging? You haven't taken anything. Where is the condition? We took the issue to the Supreme Court. In January, we argued the case, and I decided to include some clips here of the oral argument, in which a couple of the justices, if anyone knows, you guys are all familiar with the different justices on the Supreme Court, Chief Justice Roberts was beside himself with respect to this argument that the government had made that money is not property protected by the takings clause. That if you confiscate, or if someone comes in and confiscates your money, that's not a taking. How could that possibly be? And so you're going to hear some exchanges, some pretty heated exchanges between Chief Justice Roberts and Justice Scalia, who in particular was exasperated by the government's argument. I'm wondering if anyone knows how to get some audio here? It's much better when you actually hear the voices with the exasperation. There you go. It's not a bad idea. There we go. Let me try that again.
If I understand your question, Mr. Chief Justice, I don't think so.
So basically the government was arguing, there's nothing under the federal constitution, that was the first argument they were making, nothing under the Constitution that protects your rights, that protects the ability of the government to limit what they can and can't demand from you. Pretty remarkable proposition. Then he sort of changes his tune a bit.
Just to nail it down, your position is that there is no limit in the federal constitution on what the agency can demand as a condition for the issuance of a permit.
No, I don't think that's our position. First of all, the due process clause makes certain they impose conditions. The equal protection clause makes certain they impose conditions.
But the takings clause does not.
So what he was getting at here, it's an interesting constitutional point. There are certain clauses that make a property owner might be able to bring to challenge a money confiscation. The problem is the due process clause is a very difficult claim to make. The due process clause asks this question: does the imposition of the condition substantially advance a legitimate state interest? So if you ask yourself that question with respect to a money exemption, let's say the government says, we need this money for you, we need this money in order to improve certain state-owned lands because they have problems, there are wetlands problems on the state-owned lands. So we think we need your money to help improve those lands. You can easily satisfy the due process clause standard. Why? Because taking your money substantially advances a legitimate government purpose. The government is certainly within its rights to improve its own wetland property. So it would easily satisfy the due process clause. But more importantly, it doesn't ask the right question. The question that we were asking is this a taking? If the government confiscates your money in the permitting process, has it taken your money? That's the question. So the due process clause does not ask that question. Equal protection clause simply says, are you the only one being singled out for this? Or are there others in the community also being singled out? Well, of course, that doesn't matter if it's a taking. We don't care at Pacific Legal Foundation, certainly none of you would care, if 2, 3, 4, a multitude of property owners were being extorted. It still would be a taking of their property. So it doesn't matter even if they satisfy the equal protection claim, you would still have this question out there, unanswered by either of these claims, as to whether the confiscation was a taking of private property, and that was the question. And Chief Justice Roberts was saying the most obvious clause in the Constitution does not apply, and that's what he was trying to get his head around. This is a lot more fun than this next exchange.
If I understand your position, cash is magical, right? The government can come in and come into my house, take all the cash that's there, and that is not the basis for a takings claim, right? Because cash is not a taking. Does that make any sense?
Of course, we don't think it makes any sense, right?
The problem with extending the takings concept to a monetary obligation, which can be paid for out of sort of undifferentiated fund, right, is that it has no logical stopping point. I mean,
The stopping point is don't take my cash.
well,
The answer question is that's okay. It's not a taking, right? I may have some other cause of action, but not a taking. The government's coming in and taking my money.
So Scalia was not pleased with the argument that Florida was making. And actually, the Obama administration joined in the lawsuit in support of Florida, obviously, and argued we had the Solicitor General representing the Obama administration, and we had the Florida attorney representing Florida, and then you had, I was representing the property owner. And it was a very heated oral argument. It was very clear who was going which way, as you can imagine in a lot of these cases. And it took them 6 months to decide the case. We waited, well, there's Obamacare. It took them 6 months to decide the case, but we finally got a decision in June. The last week, actually, of the court's term. And we got two holdings in this court opinion. Number one, the entire court, even the liberal wing of the court, agreed that it doesn't matter how you phrase the exaction, that all exactions are subject, if they follow certain other criteria, that all exactions should be subject to this high-level scrutiny. In other words, It doesn't matter if the government says first accept the condition and then we'll approve, or here's our approval if you accept the condition. It doesn't matter how they phrase it, governments are subject to this heightened scrutiny if the liberals say you follow certain other criteria. So we got a unanimous ruling on that one issue. We got a split ruling, 5-4, on the question of whether money is private property under the takings clause, if you can believe it. And the majority, written by Justice Alito, said that of course money is private property under the takings clause, that if the government comes in and demands or imposes a financial obligation on you in the permitting process, that exaction will be subject to heightened scrutiny. In other words, now, government across the country, federal, state, and local agencies, will have to demonstrate that there is a connection between what they're demanding of you in that monetary exemption and the impact of your project. So we're going to hopefully see a shutdown in a lot of these monetary exactions that we've been seeing across the country. So that's all for property. Are you guys ready for Obamacare? Yeah. I mean, not ready in that sense. Ready for the presentation on Obamacare. So there's Obamacare. He wants you to buy health insurance and other things. So this has been obviously an ongoing issue since 2010. It's called, perhaps as a misnomer, the Patient Protection and Affordable Care Act. And how many of you are not familiar with the nuts and bolts of Obamacare? Don't be shy. Okay, a few of you are. Okay, so I'm going to go really quickly through what it says and what it does. That way I can provide some context. Why did this become suddenly so loud? This is okay? Okay. So, the explicit goal of the Act is to make sure that everyone is insured. The implicit goal, at least for many of us, is to nationalize the system because it's going to break down as a result of Obamacare. And then you're going to have the leftists run and say the American system is a total disaster, we have to go single payer. That's the prediction, right? But the explicit goal is to make sure everyone's insured. How do they do it? Well, the first thing they did was to make sure that every private insurance company accepted everyone, even those with pre-existing conditions. Now, I know this is a very touchy subject for a lot of people, but it seems bizarre to require an insurance company, to require any kind of insurance company, let alone a health insurance company, to accept those with pre-existing conditions. It seems that that is no longer an insurance policy, that's something else. But they're requiring everyone except they're requiring all insurance companies except everyone. But how are they able to get the insurance companies on board? By making sure, of course, that everyone was forced to get a federally prescribed minimum health insurance coverage. So no longer could you be reasonable, say maybe a 25-year-old, healthy 25-year-old, and say, well, I'll get catastrophic care in case something major happened, cancer or something like that. That's not sufficient under the law. You have to get a lot of things that you otherwise may not even need. And the idea is to get everyone into the system purchasing a certain minimum in order to support the first mandate that all insurance companies accept those with pre-existing conditions. So the focus of much of the litigation, as many of you may know, was the individual mandate, requiring most Americans, there are certain exempt groups, to purchase health insurance in the private market, whether they wanted it or not. Again, no self-insurance, so if you're a multi-billionaire and can simply pay for health care as the need arises, you still need to get health insurance. No catastrophic policies, as I said, and there's a penalty for non-compliance. There's a penalty imposed on you, I forget the amount, a couple $1,000, if you do not get health insurance by the year 2014. And it's important to note that this was a penalty. In the Act, it was called a penalty. So you have the individual mandate married to a penalty. That was the central provision that made the whole thing work. Sounds like a good policy. Well, we don't think so. Maybe, but is it constitutional? Everyone remember this? When then Speaker Pelosi was asked, well, are you sure it's constitutional? And she's, are you serious? I don't think she had even read the bill by that point, but. And then you had this fellow, Peter Stark, when asked, well, what can the government not do if it can require you to engage to buy a private product in the marketplace? And he said this: the federal government can, yes, do most anything it wants in this country. So anyway, the mandate and the penalty, again, they were proposed under the law to be a single provision. And they were justified, again, in the law on Commerce Clause grounds. Commerce Clause. Everyone knows what Commerce Clause is? Most of you do? Commerce Clause is a provision in the Constitution that says that the federal government can regulate interstate commerce. Now, a little known point a historical point about this provision, it gives Congress a lot of power, obviously, but it was greatly expanded in the 1930s to mean almost anything. But originally, the word regulate in the 1700s, when it was first ratified, it actually meant to make regular, which meant at the time to tear down any trade barriers and restrictions that states would build up one against the other for economic protectionism and whatnot. At the time, you had states vying for this and that and the other, and so the federal government wanted the power to tear down restrictions. In other words, to make the economy freer. The idea was not, as it came to be known later, to impose regulations and prohibitions and mandates. It's the exact opposite of the original meaning of the Commerce Clause. But in any event, in the 1930s, it was greatly expanded to mean almost anything. The problem, of course, though, if you think about it, is, well, what is interstate commerce? It's a kind of activity, right? If you're engaged in interstate commerce, you're doing something. Obviously, there's a predicate for that you're engaged in some kind of an activity. The problem with the individual mandate is that it actually regulates inactivity. It forces you, the uninsured, say, who is standing on the sidelines of the marketplace for health insurance, it actually forces you to engage in activity. So it's not actually regulating commercial activity, it's regulating commercial inactivity. And that, many of us felt, was one step too far even for the Commerce Clause. And that was the argument that was made in a variety of cases that were challenging Obamacare at the time. And the United States Supreme Court, as many of you know, in 2012, issued a decision, a very interesting decision, that said, we are going to bifurcate the individual mandate from the penalty. We're going to treat them separately. 5 justices on the Supreme Court, Chief Justice Roberts and 4 conservatives, said the individual mandate violates the Commerce Clause. Why? Because it attempts to regulate inactivity. And that would be unprecedented. If the government can do that, what can't it force you to buy? But Chief Justice Roberts, with the support of the 4 liberals on the court, said, we're going to treat the penalty as a tax. And if we view it as a tax and not as a penalty, we believe it falls within Congress's power to tax. And the reason it said it looked like a tax, I mean, Chief Justice Roberts, who wrote the majority on this issue, was very tepid in his analysis, and wasn't, to me at least, when you read it, he doesn't seem very persuaded even by his own argument. He says it kind of looks and feels like a tax. I mean, it's collected by the IRS, which is true. It raises substantial revenues, an important point to keep in mind, which is very true. It will raise substantial revenues because many people will not be able to buy health insurance and will therefore have to pay this tax. All it does, it's not really punishing you for not carrying health insurance. It's just taxing you for being without it. I don't know what that means, but that's the distinction Chief Justice Roberts made. So here he goes. All of us were very surprised, by the way, with this decision because the government, as I recall, the government mentioned this as an alternative argument at the oral argument. So it wasn't fully briefed. The argument wasn't fully vetted, even at the oral argument. I think the government mentioned it in passing and said, well, look, even if it doesn't pass muster as a penalty, we think it can be interpreted as a tax. And we have the power to levy taxes. And so the problem is that the court didn't really consider the full implications of its decision, declaring this to be a tax. Well, in a way, for those of us who oppose Obamacare, that was sort of an in. Because as soon as we read the decision, we thought to ourselves, well, gee, I mean, certainly Congress does have the power to levy taxes, but there are provisions in the Constitution that limit the way in which taxes can be raised. And this is not something apparently the government had thought of, and certainly the Supreme Court did not consider. So the question became, fine. If it's a tax, does it satisfy other provisions of the Constitution? And so we come to the origination clause, which is a little-known clause in the Constitution, but an extremely important structural protection that says that all bills for raising revenue shall originate in the House, not the Senate. The Senate can amend tax bills, but it can't originate in the Senate. What is the purpose? Many people have asked me, well, isn't this sort of a technical argument, and does it really carry much constitutional sway? Well, this is an extremely important provision. As you recall, the revolution was sparked by the idea that we should all be taxed only if we're represented. And the idea was to have taxes raised only in that chamber closest to the people. And at the time, the House of Representatives was the branch of government closest to the people. As many of you know, the Senate was elected at the time by state legislators. And so they weren't directly representing us, they were representing the states. Unfortunately, that was later changed. But in any event, the provision is still there that all tax bills have to arise in the House. The difficulty, of course, is that this is our client, Matt Sissel, whom I'll speak about in a second. The problem is how this bill, Obamacare, was originated. As it turns out, the House passed a bill for home buyers' tax credits. Passed the bill, had nothing to do with health insurance, let alone Obamacare. They passed the bill. It went up to the Senate. The Senate, in essence, kept the bill number, wiped the bill clean of its contents, changed the title, and changed it to Patient Protection and Affordable Care Act, filled it with Obamacare, and passed that. And they said, because we still have the same bill number, we were just amending what the House passed. And there's no dispute, this is exactly how it happened. That it originated, the entire bill originated, the substance of Obamacare originated in the Senate. And so we saw this as an opportunity maybe for striking down Obamacare via not the Commerce Clause, but the origination clause. This is our client, Matt Sissel. He is an artist in Iowa who is young, healthy, but uninsured. Nevertheless, he has plenty of funds to take care of his medical needs as they arise. Why doesn't he want health insurance at the moment? He's an entrepreneur. He started his own art business and simply wants to spend his money in some other way. He wants to invest in his art business. And so he's a very principled individual, thought that this idea that the federal government would mandate that he purchase something in the private market was unconstitutional, and so he came to us for representation. And we actually filed suit right when the law was passed in 2010, but we were one of many cases that had to be put on pause while the Supreme Court made its decision in another case. But now that the court has made its decision, we're taking this case up now through the court system and hopefully getting it to the Supreme Court. So here's a little bit about Matt. Matt, we filed in the DC District Court, which is sort of where all the action happened, obviously. We made the argument that this is a tax, as the Supreme Court has declared it to be, but it's unconstitutional because it originated in the Senate. We lost to a recently Obama-appointed judge in the DC District Court, so we weren't terribly surprised. The judge basically deferred entirely to the government and its position that it essentially was an amendment to a bill that had originated in the House, even though they had absolutely nothing to do with each other. The case now is pending in the DC Circuit Court of Appeals, where we do have a bit more hope. That court is populated by a lot of good conservative judges. We do hope that we pull a panel of 3 judges where we have at least 2 conservative judges sitting on it. But if not, regardless, either party, whichever party loses, it's going to go to the Supreme Court. And why are we optimistic that this case may be coming back to the Supreme Court after it was there just 2 years ago? Many of you may not know, but there's a rule at the Supreme Court where whenever you petition the Supreme Court to accept the case, only 4 justices need to say yes. We want to review this case. If you read the opinion in Obamacare from 2010, you had 4 very angry conservative justices who wrote a dissent and thought it was outrageous. You felt the outrage in this opinion that Chief Justice Roberts, probably at the very last minute, switched his vote and went with the Liberals. So you have a very outraged set of 4 judges who may be very well interested in hearing this issue again. Otherwise, I would say that in ordinary circumstances, the Supreme Court normally will not take up the constitutionality of a law once it's passed on it just 2 years ago. I mean, that's a very rare thing. But given the unique circumstances of this case, I think we have a better than average chance of seeing the case heard again by the United States Supreme Court. This case is different from others. You may have heard about the other cases. There is a lot of litigation challenging Obamacare. A lot of them have to do with religious objections. For example, the idea that the federal government would require a religious organization to make contraception available to its employees against its religious beliefs. That issue is being litigated across the country in a number of cases. I believe this is one of the few, if not the only, and I haven't recently checked. This is one of the few that challenges the heart of Obamacare, the individual mandate and penalty, the individual mandate tax, on the grounds that it violates the origination clause. And we have done a lot of research on the history and purpose of the origination clause, and we think that we have a very solid argument to have that law stricken down under that provision. That concludes my remarks. I wanted to say before I take